Good morning. There have been some new developments in the case of a Waterbury man believed to have been held captive in his home for the past 20 years. This week, police released a number of photos and videos taken from the home that was intentionally set on fire, and what the young man has said was an effort to finally gain his freedom. And the attorney for the mother who was accused spoke to the media defending Kimberly Sullivan, the stepmother charged in that case.
What we're really going to need is some jurors that can keep an open mind. What we have is millions of people behind their keyboards, behind their monitors, having convicted her without knowing anything about this case.
Back with me again this morning to talk about what happened last week, defense attorney Walter Hussey. He's been following the case and providing us with analysis. Welcome.
Good morning. So
you actually spoke to Attorney Colitis, her lawyer, I know just very briefly, but what did he have to say?
Oh, briefly I asked him, what's your position? Is there anything I can advance for you? And he said, yeah, she's not guilty, and she's got to be presumed innocent. He's been hammering that home, and he feels like no one believes that to be the case based on all the information that's been disseminated by the press. And he said he's looking forward to his day in court. Now, obviously, he's not going to tip his whole hand to me, but he seems like he's very adamant about having a trial.
Some of the things that we heard him say about that innocence were, even in the warrant, police say that this young man said he would take the trash out. That was one of his daily chores. And Attorney Colitis said, well, why didn't he make a break for it? He said he was, 5'9" and 68 pounds. Well, there was food in the fridge. Why didn't he eat it? This was not a man held captive. Can you see that as a plausible theory you could present to a jury if you were Kimberly Sullivan's defense attorney?
I think you could present it, but is it plausible? Because the issue then, Eric, if she didn't do it to him, then he did it to himself. And let's just say that was the case. Wouldn't she have some sort of obligation to try to get the young man help? I mean, I think it's pretty clear by his condition overall. It's just so deplorable that either if he did do it to himself, then why wouldn't you help him, or you did it to him yourself, meaning Miss Sullivan?
One of the big stories over the last week was the release by Waterbury police of the pictures, some body camera videos, a lot more information about what they found inside that house. Did you find the release of that information unusual?
Very unusual. I think to understand, Eric, I know you understand it, but for the public, discovery, that's what it's called. So when the state of Connecticut is prosecuting anyone, what they'll do is they'll collect all the reports from the various officials, would be police, fire, medical, anything in this case. Once they obtain it all, they release it to the defense attorney. It's called open book. So basically they have to, anything they have to give up to you, and then you assess it. So he didn't receive it, meaning the lawyer, and it seems to me bypassed the state's attorney and went straight to the media. That is very unusual.
And he was saying, he called it a deliberate effort to influence public opinion. But really, maybe with a little bit of a roll of the eyes, a lot of criminal defense attorneys would say they're usually fighting to get that stuff in a timely manner, as opposed to it all being dumped out to the media.
That's true. Usually it does take a long time. In my experience, if you have FYI something, sometimes they're going to deny it. They could have denied it, as you know. They have 3 days to deny it, but they just said they were more than willing to basically get it out to the public. You have to ask yourself why. And I don't even know if it's necessary, to be perfectly honest with you. I mean, the case itself is a long way from going to a jury. I know he's upset about it being out there right now. It doesn't help his client. But, I mean, 12 months away, 18 months away from a trial, I don't think it really matters.
He had said that it would poison the jury pool. Is there anywhere in is there anywhere in the state of Connecticut he could get a jury that doesn't know about this case, in your experience?
I suggested to you maybe the moon, but no. I mean, and by the way, no matter where he goes, let's just say he went to, I don't know, Danielson, Connecticut, very far away from Waterbury, right? Maybe people haven't heard of her, but the bottom line is they're still going to see the same evidence, right? So the only thing is, I think it's almost better to get it out there up front and say, okay, you've seen this information. Do you have any preconceptions? Can you presume her to be innocent? And if people are going to say no, and someone might say yes, and that's who you want.
So it's almost, it may be working in his favor a little bit that it's been so out there, because then he can ask about it.
For sure, and he will ask about it. I mean, it's one of the things he definitely talk about during jury selection. And people are under oath, and they have to tell you, you know what, I have a problem with this case. I'm sure a lot of people will tell him that, but there's going to be some people that are skeptical. And by the way, that's the word he did use for me. He said, I'm looking for people that are skeptical, okay, skeptics, okay? And I think that's exactly what he wants. Not someone that's going to roll just being what they're being told. They want to judge for themselves.
And he's been trying to make a lot of hay of every little, there was a lock on the door, but she didn't use it. There was food in the fridge, but we actually have let's listen, we have a soundbite of him talking about that.
There was food in the fridge. There was food in the cabinets. She brought food home.
But was he allowed to eat it?
Yes, absolutely.
Was the door locked on his room or no?
No.
Okay, is it normally locked?
No.
Okay, it's normally open?
No, yeah.
And he has free reign to go out of there whenever he wants?
Yeah.
Okay.
Where are the handcuffs? Where are the chains? Where are the signs of restraint?
So that's some of the things we talked about earlier on in our interview, Walt, was that idea. I mean, he wasn't chained to the wall, in some medieval type, setup. But that doesn't necessarily mean that she wasn't holding him there against his will.
Well, psychologically, mentally, emotionally, I'm sure that all enters into the equation. I'm sure they're going to have a doctor explain all this if they, in fact, go to trial. I'm sure the state of Connecticut will have a doctor explain how someone could be under the spell of someone, right? And maybe for a lot of different reasons. Maybe physically. I mean, I heard he had difficulty. He wasn't really ambulatory, right? So he had a hard time walking. It's not like he's going to be able to flee. Keep in mind, he set that fire for a reason.
And that was, according to police, just all part of this sudden plan he had to finally make his escape. And that's got to be key evidence to put in front of the jury.
For sure. But at the end of the day, he's the evidence. I keep hammering this. I mean, you have to explain how this young man finds himself in this condition. It's going to be really hard to do. And I'm not against the defense attorney by any stretch of the imagination. I'd be a hypocrite otherwise. But she is presumed innocent. He's going to have to find people that agree to that concept, listen to the evidence, and then the secondary nature of his problem is dealing with the evidence, which is him. Okay, so this young man at some point most likely will have to testify, and that's going to be really difficult.
Only about 30 seconds left, but timeline-wise, let's just say he's going to go all the way to a trial. When are we talking?
I'd say about 18 months.
So still a lot to do in court. We're really early in the legal process.
Oh, for
this
sure.
thing.
Definitely, absolutely. It's a long process.
And sometime between now and then, there could be a plea bargain, there could be something else along the way, or a trial.
Well, there will be. So the state's going to offer something at some point in time. It'll be up to her and the attorney to say yes or no. And if they say yes, then they hammer it out. There's a guilty plea, and then whatever happens, happens. Or if she says no, then she's going to get her trial.
All right, and we'll see where it ends up. Walter Hussey, thank you so much for being with us.
Thank you.